in compliance with the order of 17/5/2023. So, Lordship had given liberty to the petitioner and respondents.
We'll be filing it, my lord. Within 2 days, we are filing an affidavit replying to that affidavit they have filed, my lord. Within 2 days.
Very well. How is the situation? The situation continues to be the same?
Same, my lord, is more, in fact. The ground reality is more. Maybe my learned senior will not agree with me.
We think it's worse. See, every 2 weeks or 3 weeks, I take that drive.
Lordship.
And the
You
AV
can see what is happening over there.
and AV bills, my lord, now are being issued in the sister company's name, my lord. It's very unfortunate what is happening, my lord. It seems, my lord, the court order, repeatedly the courts are...
You indicate what is there on paper. We have to have something on paper.
My lord, we will just 2 days time.
Very well. 2 weeks.
2 days, my lord.
2 days.
Yes.
Since the petitioner seeks some time to file its affidavit, let the matter appear a week hence.
My lord.
The affidavit should be filed by Monday's date with copies forwarded to both the state and the 14th respondent.
My lord.
Do you have anything to say now?
My lord, my instruction is that the Guwahati coal, only the coal auction by Coal India Limited, my lord, that is being exported, and that is with proper papers, my lord.
So you've not.
But as far as what was happening earlier, my lord, that has been arrested to some extent after the intervention of this honorable court.
You demonstrate to us it is done. We are very happy.
But this is as long as the matter is pending before this.
Yeah, that's why. You show us that the Guwahati coal is being exported over here. We are very happy with that.
Coal India coal, my lord.
Yes, Coal India coal.
My lord. I'll bring on report, my lord. I'll file that.
That is number one. Number two, your land customs authorities must also ascertain the origin of the coal.
My lord, I spoke to them, my lord. They are saying that there will be a conflict of duties, my lord. Because as I pointed out on last occasion, my lord, in the DMR is certifying, my lord, that coal entered from Dina Dubi and they are checking it at Gasopada. Now, for us to, my lord, that is what is causing.
Very well. Suggest something which can be done. Suggest where we can bypass the state. Yes.
Hello.
Item number 2.
UA bills. Let them file UA bills. We'll give a reply to that.
Sir, UA bill.
No. What is it? The UA bill has been continuously given to so to the sister concern.
Sir, but sir, I got 1,000 challans in auction. Out of that, 500 challans I got. I was transferred.
Yes.
Item number 2.
Yeah.
May it please your lordships?
Yes.
The conducting counsel, Mr. A.C. Kayal, couldn't be here, lordship, due to some personal difficulty. If my lords could have the matter next week, maybe.
Very well. Since the department seeks some time on the ground of inconvenience of counsel, let the matter appear 10 days hence.
Highly obliged, lordship.
2, 3, 4, 5 minutes.
Item number 6.
May we please your lordship? Lordship, I pray your lordship may be pleased to allow me to withdraw this with liberty to file fresh, because lordship last order I was supposed to collect some documents. I could not get it. In fact, the petition was adopted.
The petitioners seek leave to withdraw the petition with liberty to file afresh. This paragraph, this prayer is made since certain material facts may not have been disclosed and key documents not appended to the original petition. Full stop. Paragraph. Accordingly, liberty is given to the petitioners to withdraw the petition, to withdraw WPC number 475 of 2022 with liberty to file afresh, full stop. However, comma, it is made clear that such liberty will hold good if the petitioners had a cause of action or a right to institute WPC number 475 of 2022 in the first place, full stop. This liberty may not be construed as fresh liberty, irrespective of whether any cause of action or right survived at the time of the institution of the present petition, full stop. Paragraph MP, MC, whatever is disposed of, there will be no orders to cause.
Deeply honest.
Only to correct this, but if you did not have a cause of action or a right, liberty will not
Yes.
confer any further right.
No change.
Item number 7. Please, Your Lordship. Your Lordship, I'm praying for further accommodation, Your Lordship.
Why, madam?
The conducting counsel has some personal difficulty, Your Lordship. Your Lordship, kindly afford us 1 week's time, Your Lordship.
We've been granting you time on several occasions.
Your Lordship, kindly afford us one last opportunity, Your Lordship.
Further prayer is made for adjournment on behalf of the appellant. Full stop. A final opportunity is afforded to the appellant, and the matter is adjourned for 2 weeks. Full stop. No further accommodation should be sought.
Right, Your Lordship. Item number 8.
Please, Your Lordship.
Yes, yes.
May it please, Your
Yes.
Lord, I have almost finished my argument on last date of hearing, my Lord.
Yes, we are giving you a chance to do it, because what is completely against you is Article 326.
Yes, my Lord, that is the article which I wanted to be. But if your Lordship will see, I read Article 326
number
once
one.
again.
Number two, it's the Supreme Court, but I don't think the interpretation of what was the intention for Office of Profit is being correctly interpreted. Anyway,
326, my Lord, kindly see 326. I also,
326
it's a right to vote, my Lord. It's not relating to right to contest election, my Lord.
Is there anything in the Representation of People Act?
But, my lord,
Give us
there is a
the
judgment.
representation.
There is a judgment in favor of the petitioner, my lord, respondent, my lord, saying that it is a constitutional right and that right can be taken away, even right to contest election, right can be taken away by way of law.
Only by law,
Only.
not by a rule.
Or by a rule. That, to that extent, I concede to that legal position, but 326 will not come to the rescue of. The second issue which I wish to flag before your lordship is that this amendment has been.
Let us see if the right to representation of People Act has anything.
Also, my lord, Article 173, my lord, prescribes the qualification for members of legislature, my lord. Article 173, my lord.
Does that also say that by law?
Is by for the members, my lord.
Article 173 is worded in the negative, meaning that a person shall not be qualified.
Unless he is reasonable.
So, the corollary of that is he will be qualified, but it does not give a positive right of qualification. It only says what will be the ground for disqualification. If it had given a positive right, then that right could not have been taken away. But it's deliberately not given a positive right, it's given only what will amount to disqualification. But it is elementary that along with citizenship, there is a concomitant right both to vote and to stand for election. And that is a constitutional right, which should not be taken away otherwise than in accordance with law. And that law can be made by a proper, that law cannot be delegated legislation. Where is the judgment?
Yes, Raj Bala, my lord. The citation is, my friend, is Justice Chelamistra's judgment, my lord. It's not there. Raj Bala. Give me the citation. WPC 6671.
It's part of your compilation?
It's part of my friend's compilation, my lord.
Very good. So tell us which one?
Also citation is there, my lord.
Which one? Oh, item number 5.
It is a reported judgment, my lord. Is 2016 2 SCC 445, my lord.
2016.
2 SCC 445.
173. You see, there is something. Do the paragraphs agree? What is paragraph 38 in the SCC?
We therefore proceed on the basis that subject to restrictions mentioned above, every citizen has a constitutional right to elect and to be elected to either parliament or state legislature.
No. That's the problem. Get us the book, please.
That is paragraph 40 of the
come to paragraph 36 of SCC.
Article 84.
173 purport to stipulate qualifications. 102 and 191 purport to deal with disqualifications. All the four articles authorized further qualification as disqualification. So you see the importance of it. It's not even a state legislature
in parliament
which has the right to do it.
As per.
Because if you come to 191,
yes, Lord.
If you come first to 173, we are not dealing with parliament now, we are dealing with state legislature.
Yes, sir.
Qualification for membership of state legislature 173, A, B, forget that, C, possesses such other qualifications as may be prescribed in that behalf by or under any law made by parliament.
Yes, Lord.
So that one state cannot have another rule, another state cannot have another rule.
Yes, Lord.
It has to be uniform as made by parliament.
Yes, Lord.
Then, even if you come for disqualification, 191, which is for state legislature, come to the residuary clause, E, 1E.
Any law made by parliament.
If he is so disqualified by or under any law made by parliament,
only parliament has power.
Only parliament has power
to make laws.
So if you do not have the power, a body under you does not have any power at all.
Yes, Lord. Now, what is falling from your Lordship, I completely bow down, Lord.
The only thing is that whether it would be an office of profit. If it were an office of profit, then you wouldn't have to change the law.
No, yes, Lordship. Now, the other.
It's because you recognize that it isn't an office of profit that you make the law, make the rule.
Yes, to that extent.
So therefore, the moment that is understood.
No, my Lord, my submission is slightly different, my Lord. My submission is, my Lord, that for example, my Lord, for government employees, there is a restriction. that as long as you are part of the government, you can't contest election.
Yes.
This is the restriction which we have imposed by executive.
What is the intention of that restriction?
That is the second aspect. First aspect, whether I have competence to do that or not, my lord. So far as the competence is concerned, my lord, if I have competence to say that those who are working for me can't contest election, if you want to contest election, I am not taking away your right. You resign and contest election. So therefore, whether your lordship would have to construe whether we are taking away.
See, we don't have to go into this further consideration.
Yes, sir. That I fully agree with that.
Because till such time that Rule 6 was amended, previous position as it was,
yes, Lord,
is your acknowledgement that he has your express acknowledgement,
yes, Lord,
not tacit acknowledgement.
Yes, Lord,
because you say he can do it with consent.
Yes, Lord.
Therefore, you expressly acknowledge
yes,
that
Lord.
that is not an office of profit.
Now, there, with respect, my lord, I have one more submission. Because, my lord, what is being tested is the amendment. Whether amendment, if amendment is good, bad.
What is being tested is the right of that person occupying that position,
yes, Lord,
to contest.
Yes, Lord.
And whether the interference or impediment put by you,
yes,
is arbitrary or
constitutionally, yes, Lord. Now, so therefore, it is being held against me that since it is not an office of profit, therefore my policy is arbitrary.
That since it is not an office of profit,
yes,
you do not have the competence to impose that disqualification.
Yes, I would argue slightly differently, because what is if there is a declaration that now all my what is being now, lordship, the declaration is being sought that those who are working for government aided college are not holding office of profit, and therefore the policy abridging their right to contest election or to contest or hold offices particular is bad.
We are not on policy. We are not on policy. We are on authority.
Yes, competence of.
We are on authority. We are not on policy.
Now, so
if it were a matter of policy,
so
you
therefore,
can do whatever.
So therefore, my lord, if for examining this aspect whether I have competence or not, there is a separate set of procedure prescribed, my lord, under Article 192.
No. Article 192 comes into play when a person is elected. Thereafter, a question arises as to his objection.
Yes, sir.
But if prior to the election,
yes, sir,
it has been challenged in competent proceedings,
yes, sir,
and the court has pronounced thereupon,
yes, sir,
then you have a right to contest that judgment. But it no longer is an open field for you to do whatever you want.
No, I'm not on that. What I'm trying to submit, my lord, is that right now this amendment.
The governor.
Amendment is.
The governor will be bound by the judgment of this
yes,
court.
Yes, sir. The amendment is bad in law because it has no rational. With the object it seeks to achieve.
No.
If that
the
is
amendment is bad because
I have no competence.
We do not have the authority.
We are not
going into grey areas.
Yes.
We are going into authority.
No.
Jurisdiction.
So, yes, Lordship. So if I have the authority, then now your Lordship kindly examine this aspect from the angle that I have the authority so far as government employees are concerned.
You have the authority
so far as government employees are concerned.
What kind of authority?
Authority to restrict them from contesting.
No. You don't have that authority. That is by virtue of the constitutional provision. So it's not your authority you're exercising.
Under Article
it's a constitutional impediment.
Under Article 1
places them under that embargo.
So then the question which falls for your Lordship's consideration is that this person is holding office of profit or not. If
that is tacit in your previous rule.
So, my lord, if the previous rule will, because this issue has to be independently examined. It has to be independently examined, my lord, because
You cannot control. You see, you cannot control. We've seen even your rules. Your rules say that 4 out of 9, possibly 4 out of 8
yes, sir,
in the governing committee will be your nominees.
Yes, sir.
But you again cannot dictate to your nominees.
I bow down, my lord.
If it were there that your nominees will have to vote according to or will have to decide according to your dictates, we could have understood
Yes,
that.
sir.
All that you can do is, if your nominee is not, if you are not happy with your nominee taking a decision, you can withdraw him.
Yes.
Another nominee goes in.
Yes.
He also does not do it according to your, you also take him back.
Yes. Now,
But the nominee is not obliged
yes, Lord. If your lordship see it,
follow your dictate.
if your lordship sees in the larger perspective, so there are number of tests which are laid down. One test is that the remuneration should come from the government. Other
Only
test one. So now is the
You
question.
have no say in his appointment.
So far as his
You
appointment,
have no say in his dismissal.
no, your lordship, in dismissal we have say because government approval is required in appointment.
That is, you have no say in his appointment. You do not choose. He
chosen by the
the
management.
college chooses. The college sends it for approval. There you have to go by whether he is fit or not, whatever your considerations
The
are.
identical question fell for consideration because we did some more research in India also. Identical question fell for consideration before Kerala High Court Division Bench, my lord. So there in the Kerala High Court held that it is an office of profit because though the appointment is being made by the governing body or manager there, but still there are number of checks and controls and a detailed judgment was passed. But only thing is that this matter is pending because this matter travelled in Supreme Court, my lord, and this matter is now pending in there is a stay and a notice is pending before there.
Very good. So that's
But there are certain
it's
issues.
not attained finality. So our matter will go and be tagged with it.
So if I can place the judgment,
It is the judgment, but our matter will go and be tagged with it. And you have to show over there that the rules are identical.
somewhat identical. I can't. Because that is the case dealing with the schools, my lord. Here our case is dealing with it, but the principles which. Para 1, my lord, and
Let us see the circumstances.
para 1 and then 20, my lord.
Where is the discussion?
142, my lord. It starts from paragraph 58, my lord, at page paragraph 58, my lord, after. And then 188, paragraph 88, my lord.
Paragraph 88.
Yes, Lordship.
These are all articles set out.
Yes, sir. 58, but your Lordship kindly see straight away 142 and 143.
No, we don't have page numbers.
Paragraph 142, my lord.
Paragraph 142.
Yes. Though the management of PDF 142, 143, my lord,
Yes.
and 144.
This is it. You have not given us copies of those previous judgments that you have cited, no? Of 65 Supreme Court?
Yes, sir, I will, my lord, actually list of books was given, my lord. I will.
Give us 65 Supreme Court. Where? Just a second, just a second. We have a comparison with.
I'll get comparison with
Yes, 65 you have given us.
No.
No, that's not it. This is SCR. Give us the book, please. The state should be able to afford Xeroxing.
Yes, sir. Problems is.
Give us a.
I'll prepare.
Give us a compilation
spiral
of all the
comparison.
judgments that
I'll do that.
cite like they've given, and then
I'll
it's easier to refer to it. Because half the place we have SCR reference.
Yes, Lordship, there are problems.
No, this is not it.
I place reliance on State of Assam versus Ajit Kumar Sharma, Bihari Lal Dobre, TMA Pi Milord.
You have cited 84(1) SCC. What is that?
That is Bihari Lal Dobre regarding test, Milord, the Office of Profit, paragraph 5.
Maybe it's that one. Yes. See, there are two distinct in that Biharilal judgment.
Yes, sir.
You first come to the Darbhanga case, the Durga Khwaja case.
Yes, sir. So there,
The Durga Khwaja case, there it was held, no.
money was coming from the,
Maybe, but it was government appointed everything.
Yes,
and
sir.
in the other case, look at what the factors in paragraph 7.
yes, Patel and Son box.
Patel and Shanbhog.
Yes, Lordship.
Look at that. But no option by reason that they work under the control and supervision of the government.
Yes.
That their remuneration is paid by the government out of government funds. That they are removable by the government, and that there is no one else under whom their offices could be held.
Yes, Lordship.
Now, over here, you may be the de jure appointer, but you are not the de facto appointer. You are only the de jure appointer. Number one. You pay the remuneration, doubtless. But you do not control their duties. And you cannot remove them. The government cannot remove them.
Yes, my lord. So far as duties are concerned, my lord, they are all statutorily regulated by UGC.
Whatever, maybe statutorily regulated by, but not government. Not government.
No, my lord, may not be state government.
No. That source has to be one. By law, I am regulated. Will not apply to, this test will not carry that far.
If your lordship kindly see in Dohre only, my lord, page 558.
Where? 558.
558.
What is that?
And if your lordship will see the test which has been emphasized, my lord, is that it's a revenue which is the earning which is going to be given, my lord. So if I can place that particular line, my lord, that the page 55, the appellant herein contended that on the true construction of Article 102, 1A of the Constitution, he could not be said to hold an office of profit under the Government of India, which held entirely of shares of one company, and the Government of West Bengal, which held entirely shares of other company because of various tests, which the government had the power to appoint, government had right to remove, government paid remuneration, and government controlled the functions and duties of the holder of the office did not coexist, and that the fulfillment of some of the tests alone did not make the office an office of profit under. He contended that his remuneration was paid by companies, not by the government. He performed the functions of the company and his duties were controlled by controller and auditor. Court rejected the plea of the appellant, holding that what had to be considered was the substance of the matter or not the form.
Yes.
So,
in this case before us, appointment of the appellant as also his continuance rests solely with the government, not applicable to you.
Yes.
His remuneration is also fixed by the government, yes. We assume for the purpose of this that the two companies are statutory bodies distinct from government, but we cannot remember that the government companies within the meaning of, which was that, 600 and whatever, 19
yes, sir.
of the Companies Act. If you know Praga Tools.
Yes, sir. Praga Tools.
1969.
Article 14 judgment, which I.
Praga Tools was, since a company is controlled.
Yes.
By the government, by a statute.
Yes, sir.
Therefore, the company has to be an other authority within the meaning of Article 12 of the Constitution.
Yes, sir.
That was the issue.
Yes, that.
The court said no. Just because the activities of a body are regulated by a statute, that body will not be amenable to the jurisdiction unless it is discharging some public duty in place and stead of the government.
Yes, sir. Now,
however, when it comes to a public sector undertaking, which is also in the form of a company, There the Supreme Court says it is amenable to Article 226 because it is solely controlled by the company, by the government. It acts as per the wishes of the government. For instance, take NTPC.
Yes, Lord.
It's a company solely
Controlled by the government.
If it is a company at all, if it's a corporation, we don't know, but whatever. Any company.
Yes, Dayaram Shetty laid down and Ajay Hasya laid down those tests.
No. There was a conflict. Ajay Hasya, there was a conflict, and thereafter it has been later resolved. Ajay Hasya was a conflict with the other one.
Dayaram Shetty, my lord.
Dayaram Shetty was international authority, airport authority. That's much before. Ajay Hasya was later. Ajay Hasya and the other judgment, there was a conflict, it was resolved.
Yes, Justice Suma Pal's judgment sitting in the Constitution bench.
No. It was later, after that also. Justice Suma Pal was in that Prabhat Sarkar versus ICCR.
Yes.
Which goes on Andi Mukta principles.
Yes.
All pervasive control.
And if your lordship in Kerala judgment, my lord, if your lordship has seen paragraph 155 also.
Kerala judgment is in its first place erroneous. In its first reference it's erroneous. Which starts at page 142.
Yes, my lord.
It goes by Andi Mukta.
And yes, it goes by Andi.
It goes by Andi Mukta.
Yes,
Andi Mukta, say for instance, if you know the 2010 case, Federal Bank. Insofar as its banking activities are controlled, there is a possibility of being amenable. But insofar as its employees are concerned, master-servant relationship, that will never be amenable to a writ jurisdiction.
Yes, my lord. That's a distinction.
So, it's a government-controlled bank.
Yes.
It's a government-controlled bank. So, in the banking side of it, it will be amenable to the writ jurisdiction. But in the employment side of it, it will not be amenable to the writ jurisdiction.
Yes, my lord.
Just like utilities companies, say for instance, CSC,
yes, Lord.
power companies which have been taken over,
yes,
or
Lord.
power companies which have been privatized.
Yes, Lord.
For instance, RCSC Limited in Calcutta.
Yes.
Insofar as supply of electricity is concerned,
That is
amenable to writ jurisdiction. In master-servant relationship and contract of work, no.
So, my lord, if I draw parallel, my lord, education is a state activity, my lord. They are being supplemented by private.
No.
It's a principal
It's on the contrary. It's on the contrary. It's your responsibility
to provide education.
to provide education. It's also your responsibility as a state to ensure that there is a particular level. To ensure that particular level, you provide for a uniformity in the qualifications of teachers, even at the college level. And to ensure that qualification, that is not breached, that is maintained, you provide for a pay parity with government teachers.
Yes.
All right. This is what you do because you do not have the capacity to have so many institutions
On our own.
to cater to the public. Therefore, to ensure that at least a part of your obligation which is being discharged by private parties is not compromised.
Yes, Lord.
That's why you prop it up. And that's the distinction. When it comes to your employee, you choose, you appoint, you sit over their head. Hey, it's 9:30, why are you late? Why are you leaving at 10 to 3? You institute disciplinary proceedings against them. You constitute the personnel who will decide whether he is liable to be punished.
So there is a direct relationship of master and servant.
Forget master and servant. It's not only a master and servant relationship. It's you are controlling their activities. You exercise supervisory control over them. Apart from the fact that you are the appointer, you are the terminator. Now, in the other cases, you don't appoint. You only de jure appoint, not de facto. You don't terminate. You are not in supervision of their day-to-day activities.
Yes, my lord. The government is not.
You are not.
Not. It's management which is doing that.
Management is doing it, and management is not only you.
Management consists of the private.
Management consists of, and management can have a majority which is beyond the government nominees.
Yes, sir.
Theoretically.
Yes, sir.
Number one. Number two, your nominees have no diktat from you.
Yes, sir. So they are not fully controlled.
They're nominees, they're nominated.
Yes, my lord.
But you do not control how the nominees decide.
Yes, my lord.
The decisions of the nominees are not dictated by you.
Yes, sir. That is there, my lord. So what I was submitting for your lordship consideration is that, my lord, that in order to make out this post as office of profit, remuneration and other tests, like some sort of direct control in day-to-day functioning, in my humble submission, my lord, first remuneration is paid, and other, I need not meet each and every test.
We can understand, you see, there's a college which is functioning in some place, let's say outside Shillong. You kind of take over that college and make it part of
Government.
A government-run university. That university controls, but you indirectly control, even that we will accept. But as long as it is a private body, despite your nominees,
despite payment of salary,
payment of salary is one of the several considerations.
One of the several.
And payment of salary is in discharge of your obligation. Payment of salary is not to control them. Payment of salary is to ensure that the standard is maintained.
Yes, sir.
That people with those qualifications, you prescribe what qualifications, and you prescribe the salary which is at par with people in the government possessing those qualifications.
What has fallen from your lordship yesterday also, that the basic requirement of this test is whether they can discharge their functions independent
whether
of,
they owe an allegiance to you to the extent that you can control the manner in which they will act in the legislative body.
Yes, lordship. So if I put one extreme example, Miller, that they are the part of their teachers, and by law they can enhance the grant because after 3 years they will join. So there is an apparent conflict.
Where?
Miller, for example, budgetary provisions are made for providing aids to the colleges.
But they don't control it. So it's subject to everybody else in the house.
So yes, my lord. So they have a say. So there is a conflict.
No. That we pass orders.
Yes, sir.
For enhancement of DA.
Yes, sir.
We have a conflict because that benefits us also.
But your lordship would not pass in your lordship's own case, my lord.
May not be. They're not passing in their own case. They're not saying that I so-and-so, my salary be enhanced. No, what they're doing is salary of all
is being enhanced.
A class of persons be enhanced.
Yes,
and that that individual has one vote in a house which is otherwise constitutes others.
Yes, my lord. So what I was saying, that in the context that the idea behind this Article 191 is that you have to be fiercely independent of the government influence, or you should, and therefore
your servant who is a government teacher, you can take disciplinary action against him, you can suspend him, you can put the fear of God into him, do this otherwise. So therefore he may not have that independence. Tell us in what manner you can do it to a person in a government-aided school?
Yes, my lord. I can't quarrel with this proposition that I have only this.
That is the ultimate test. It's erroneous. Personally, I think the intention of the constitution maker was completely different from what it is interpreted in that
over the period of
Bihari Lal.
Yes, my lord.
But
now
Supreme Court says that I'm bound by it.
Yeah, one more issue, my lord. My lord. Now, if you lordship will see that now the issue has arisen about office of profit and my competence, because it is not an office of profit.
Office of profit is hardly open to you.
Yes, my lord.
But still we will allow that.
The only submission, my lord, is that in all these cases, your lordship has seen that the issue of office of profit has arisen after the person has won and challenge has been laid before the governor, my lord. This is a case where the challenge was before. But for that purpose, my lord, if your lordship will see RP Act, there is a procedure prescribed for laying that kind of challenge, and Election Commission has been given jurisdiction.
Prescribed for what?
To examine this aspect, my lord. I can just place this Representation of People Act and section 176, my lord, 146, my lord, of RP Act. And there was a judgment, old judgment of Mr. Sitalwal, who argued earlier, my lord, on this issue.
Section what?
146, my lord, Power of Election Commission.
So 146 is an adjunct to 192.
Yes, my lord. This is the, so 192.
Procedural thing for facilitating 192.
Yes, my lord. So therefore, my lord, in the constitutional scheme, my lord.
No.
In constitutional scheme, in case a person is hit by office of profit, that will go to 192. From 192.
Your question is not he is hit by office of profit.
Yes, my lord. That is what I was submitting.
146 RP Act. Yes.
So that, my lord.
Tell us what your argument is.
My argument is, my lord, is that if the pleading, I went through the pleading and the argument of my learned friend before the legislature.
Unfortunately, today, the governor cannot
Yes, my lord.
entertain,
Yes, my lord.
nor can a complaint be made till such time the judgment delivered by the regional high court, the high court that governs that legislature,
Yes, my lord.
is got out of the way.
Yes, my lord. That is that's binding on governor, my lord, that he can't do anything, my lord. So the argument which I was advancing, my lord, is that 192, your lordship may kindly see once again, 192.
192, yes.
Yes. If any question arises as to whether a member of a house of legislature of a state has become subject to any disqualification mentioned in clause 1 of article 191, question shall be referred for the decision of the governor, and his decision shall be final and binding. Before giving any decision on any such question, governor shall obtain the opinion of election commission and shall act according to such opinion. So my submission is, my lord, if my policy is not having any nexus with the object it seeks to achieve, because it is not, so my policy could be struck down on that ground, leaving open to that the question of this to be decided as per article 192.
Good, bad, indifferent. Today you have an issue which is covered by your High Court's judgment.
Yes, my lord. Now,
So
kindly.
today the governor cannot.
Yes, my lord.
In good faith, the governor cannot,
Yep.
upon receiving a complaint, act on the basis of that.
Yes, my lord. That judgment binds absolutely no issue, my lord, on that.
But we don't know today what governors and legislators and politicians do. We don't know.
What I was submitting, my lord, is that my policy is bad because it is not an office of profit.
We are not on policy.
So
we are
the
on, we are on authority.
So if, my lord, whether I have the authority to amend the rules or not, my lord.
You have the authority
to amend the rules.
Your amendment of the rules is found to be ultra-virus the constitution.
So the ultra-virus on the touchstone of
Authority.
the authority I have, but not.
You don't have the authority.
Authority in the sense that if I'm transgressing the article 191, then that authority is eclipsed by article 191, my lord. That's now if I have the authority, my lord, and then it is being tested at the touchstone of article 191. I have, my lord, a rule is in place even for contesting election as per the existing rule, they have to take compulsory leave, my lord. They have to take compulsory leave. Now this imposition of compulsory leave also, if I don't have the authority, my lord, because the question which falls for your lordship's consideration is whether I have the authority or not. With respect, I say these are the conditions of grant. I have the authority to do it, but I can't transgress the limits set by the Constitution.
It reverts. The effect of the judgment is old section 6 reverts.
So, my lord, so therefore, I am saying that if you want to contest election, you take compulsory leave.
Yes.
They are not required to take, because I don't have the authority to go to that extent also, my lord.
No, there you're imposing a condition which does not impede his right.
So, with respect, my lord, I am also not
It
impeding.
gives him a choice without leaving his job.
So now the question is whether he should take the leave or leave the job. That's a choice.
No. Leaving the job is a much higher thing than...
Yes, my lord. Degree, it's a question of degree, my lord. It's a question of
It's not
degree.
a question of degree. It's qualitatively different.
Yes, my lord. I bow down, my lord.
You say that, why is your original Article 6 there? That is because it is in line with Office of Profit. That till such time that you do this and you added political parties or whatever, we are not looking at that.
I give one example, my lord. I take leave and I contest election, my lord. I take leave and contest election. I still, then, my lord, during this period, I am not holding the Office of Profit. Because leave means that I was holding the Office of Profit, and by taking leave, now I am no longer holding the Office of Profit, my lord. So therefore, the question is whether in first instance I was holding the office which is akin to Office of Profit or not. That's the issue which I place before your lordship.
That's not every state has that. That's something you have given as a condition, and that is something which otherwise his right to livelihood is affected. What you're doing now,
yes, my lord,
is that you say you have a choice, resign and go. That is his right to livelihood which is being hit.
Yes, my lord.
Whereas when you give him choice of leave, then he has that. He still comes back and joins at the end of it.
And if I see the interest of individual vis-a-vis the interest of, my lord, there in a school or in a college there are 10 teachers, and then 10 of them decide to take leave, some for joining political post, some for election, my lord. I have to do the recruitment, temporary recruitment.
You don't have to do it. Because that private body will do it.
Private body will do it.
You don't have to do it.
But ultimately,
you don't have any headache at all.
No, but ultimately standard is my business, my lord. The standard of education, the standard of teaching, standard to the teachers, my lord. So therefore, my lord, to that extent, my lord, the amendment is promoting the education. That is all.
Right.
That is all.
This is an issue which will go to the Supreme Court, and therefore, we will. You make a compilation.
Yes, my lord.
And then after you've completely satisfied, then we'll start hearing him. Give a compilation, because we have only 3 or 4 judgments. You had given a previous compilation.
I'll prepare one compilation and in that
this compilation which you had given.
Yes, my lord.
Give all standard ones.
Yes, my lord.
There's also Maharashtra judgment which you've given. You have not relied on it.
It's not.
Just give them back to him, and so that he can ultimately give a fresh compilation. Yours we take it as final.
My lord. My lord, if necessary, I may be.
I will include his judgments also in one compilation also, so that
necessary, I'll.
Of course, if necessary, but give him advance so that we can continue.
Yes, my lord.
Give him advance thing.
in Kerala judgment also I will put in the compilation bill.
You can probably get it from a Kerala reporter.
Yes, madam. I will get it.
Kerala also has Law Times and several
yes, madam.
others.
Kerala has got some. SCC was asking for premium version, that's why.
Yes.
This particular judgment has been stayed by the Honorable Supreme Court.
That I have placed.
Mere stay does not destroy it. The reasoning is still of persuasive value.
Persuasive value.
Reasoning is still of persuasive value. Till it's set aside, it's not gone. Once it's set aside, it's no longer there. this principle, I think we were in discussion with Dr. Muzika sometime. I forgot to refer the case to him. This is in that 1991, that cycle, some kind of cycle case.
Chamunda Motors.
Chamunda
Motors.
Yes, I remember that cycle moped.
Chamunda Motors.
Chamundi moped has this. What is the effect of a stay?
Yes.
It's still.
That's still holding the field. That's the only judgment.
Animation.
That is suspended.
It's in suspended animation. It's not as if it's obliterated.
Yes, ma'am.
But once it's set aside, it's obliterated.
Yes.
That's 1991 Chamundi moped. Yes. When?
As Lordship.
No, you tell us when.
Tomorrow also I'm. Tomorrow, so I can. On Monday also. Monday, Lordship.
Tuesday, Wednesday.
Tuesday.
Give it in the list both on Tuesday and Wednesday, so that
Finish.
on both days we can. Yes.
From supplementary list, item number 1.
May please, Your Lordship. This is an application under section 11, my lords.
Who's on the other side?
State, my lords.
You're for the state.
My lords.
Any objection?
Objection, my lords.
What is the objection?
First, my lords, it's an application under 11.6.
Yes.
This is a statutory arbitration, my lords. So 11.6 would not lie in my humble submission.
Statutory arbitration under which provision?
Disaster Management Act. 66 of the Disaster Management Act.
Very well. And?
My lords. And also there's a time period of 30 days indicated in section 66.
Very well.
That is
since an objection has been taken as to the very maintainability of the petition, let affidavits be filed, paragraph affidavit in opposition be filed within a fortnight, reply thereto, if any, may be filed within a week thereafter. The matter will appear 4 weeks hence. Paragraph. This order is made without prejudice to the respondent's contention that the petition is not maintainable. So, if ultimately we find that the petition is not maintainable, we will not condone delay, we will not do anything of that kind. Your right will be extinguished.
Extinguishment. Highly pledged.
Obliged.
Item number 2.
It's a contempt petition, my lord. Notice
Contempt
what is
of what?
Contempt of violating the order of your lordship. There was an interim order passed.
You know, I have a very poor track record in contempt matters.
I understand, my lord.
I've hardly ever received any contempt.
I am also not in fear of contempt matters, my lord. But
whenever a contempt comes, I'm surprised. Contempt.
My lord, what has happened, my lord, that your lordship has seen the writ petition, so-called notice which was challenged with regard to SRGT, my lord, Shillong Ground Recreational Trust. An interim order came to be passed.
Let this petition be heard along with the main matter.
Only thing is that, my lord, the trustees who are not trustees, they are selling the land. And they have sold the land to the extent of 6 crore rupees of the trust. It's a public trust and DC is a permanent trustee, my lord. And I was having a...
You are only at the show cause stage. You have not assumed authority.
Yes.
Once you assume authority, after dismissing their reply, then you can exercise,
Yes, my lord.
including.
Yes, my lord. Only thing is that the trust, your lordship knows that all trustees have to file the case.
That is not an issue over here.
Yes, my lord.
My lord, the contempt is totally misconceived, my lord. The interim order pertains to a particular land, my lord.
His whole land.
And there was a direction, there is,
So you are making that land an island and selling all around.
And the public land.
my lord, there is no restriction on selling the land, my lord.
There is a-
Because the bona vacancy notification pertains to a particular piece of land only, my lord.
No, and trust deed says that without permission of the local government, they can't sell it. And
They
they have
have
no
a different
permission.
cause of action, my lord. They can file a suit against the buyer, they can do whatever.
That is a public, my lord.
Not a
It is a-
contempt.
You take steps against that.
Yes, I will.
And then
There is a provision.
fresh litigation over there, we can intervene.
Yes,
Yes.
Yes.
Obliged.
From the main list, item number 1.
We have also filed an affidavit, my lords, towards the lordship's last order. Well, it's something very interesting has come out that we
Yes.
wanted to point out. Well, it's the petitioners, the entire case of the petitioners hinges on the word ringi. Well, this is that matter your lordship should recollect. Nongklau ringi. Now, the records of the election commission show, my lords, that both the petitioners who are before your lordships, my lords, they are registered as only Nongklau. The parent's name is also Nongklau. The word ringi nowhere appears even in the election commission records insofar as the petitioners themselves are concerned, my lords. So what we're contending before your lordships and what has been the continuous stance of insofar as the private respondents are concerned, my lords, that there is nothing known as Nongklau ringi clan. What is sought to be projected in this writ petition before your lordships? Well, if I may just take your lordships to the affidavit filed by us, my lords. This is the affidavit filed yesterday. So we filed it yesterday. The records of the...
You got it?
My lord, it's a very detailed affidavit. I'll just have a look
See,
and.
It
My
may,
lord, but
not,
the issue, my
it, may
lord-
not, it may not be relevant for the present
My lord.
discussion.
My lord.
Because the present is what did the CM propose
My lord.
and what is the law that was passed.
My lord.
So it is irrelevant.
My lord.
But it goes to the one other aspect that if you are not that Nongkau ringi, then you have no cause of action at all to complain. Because the basis for your cause of action is that you are prejudiced. But if you are only Nongkau, you are not prejudiced. Therefore, no cause of action for the writ petition.
My lord, in my understanding, that's
That
not
is the
case.
only
My lord.
problem. The problem is not in the merits.
My lords.
The problem is in your right to pursue.
My lord.
Since the private respondents, several of the private respondents, or one,
Respondent number 6.
Number 6.
since the affidavit used by the private respondent number 6 has been served on the petitioner only yesterday, let the matter appear 10 days hence.
But obliged.
You're here, Mr. Kinter. Yes.
I'm here.
He's got the